What's in a will? No one likes thinking about the end. No one likes talking about the end. But thinking, talking, and planning for the end can save our families a good deal of stress during an already tumultuous time. My name is Elena Tajudin, and I'm a junior in high school. This project is a culmination of all my research into how to draft a will and how to execute a will as a part of my independent study into civil law. While my information is all from credible sources, I am not an attorney and this is not legal advice. So I implore you to get in touch with an attorney or a lawyer to consult before taking any action. According to CNBC, 67% of Americans have no estate plan. This means that 67% of families face uncertainty after the death of a loved one. It's important that everyone plans for the end of their life in order to save their families from that uncertainty while they are mourning already. Making a will is a lot easier than it seems, so let's break it down. Starting with the heading and background and the debt and taxes. These two sections are the most easy parts of your will. Next, the most important parts of your will, the disposition of assets and guardianship. Then you designate an executor and a trustee, and include a no contest provision and some general provisions. Give your definitions and include any trusts if you have them. The heading and background, a quick start to the will drafting process. The heading consists of your name, your county of residence, and your intention. Your intention simply states that you intend for this to be your will. Next, your marital status. If you are married, identify your spouse by name. Your children. If you have children, identify them by name as well. Your biological children, any adopted children or stepchildren. And if it is your intention to do so, declare that your adopted children and stepchildren are to be considered the same as your biological children later in the will. Next, the revocation of prior wills. This part is really only important if you have prior wills, but it's good to include, and it simply declares that this document is the only valid one. Your debts and taxes section declares that you would like your debts and taxes that are outstanding to be paid with certain assets. Simply declare any outstanding debts or taxes and include assets that you would like the money for those debts and taxes to come from. The disposition of assets is the most important part. It includes your beneficiaries, your assets, and how you would like to allocate those assets to your beneficiaries. Your assets can be liquid cash, they can be possessions, they can be properties or vehicles, anything. Dedicate them to specific beneficiaries in specific amounts in order to avoid confusion later when executing the will. Next, guardianship for your child and their estate. This section is only necessary for minors, and it's very important to include this because if a guardian is not specified, the courts can choose one of their own volition. Courts can also declare a guardian unfit, so it's important to declare a guardian that you think would be deemed fit by the court to take care of your child. This part is very important because you want your child to be in the hands of someone you trust and you know. It's especially important if you want to designate someone as a guardian who you think the courts would not determine as next in line. The executor is appointed by the testator, you, to carry out their will. It can be anyone of your choosing. Next, the trustee. This is only necessary if you're including trusts, and the trustee will administer property and assets from those trusts. Next is the no contest provision. This provision is completely optional, and it states that if one of your intended beneficiaries contests the will, meaning they try to assert that your will is invalid or unfair, and they lose that contention, they also lose their right to the inheritance that you originally dedicated to them. It is entirely up to you if you deem it necessary and you want your will to be executed that way. The general provisions vary depending on your situation. They apply to circumstances that might occur due to your relationships and your life, and they basically state how the will should be interpreted in unique circumstances. For example, they address issues like, how will a divorce impact your will? They can also clarify language like, the term issue, which refers to descendants of the decedent. If you have adoptive children or stepchildren, a general provision can state that your adoptive children and your stepchildren are included as issues. So basically, it prevents you from having to redraft your will should an unforeseen circumstance occur. So, for example, if you were to go through a divorce, it prevents you from needing to redraft your will after that, especially if you don't have time to do so. These also, you should consult with an attorney before choosing them, because everyone has different needs. Next, definitions. To keep things clear, define terms that could be misunderstood. Your executor and you might have different interpretations of a word and its meaning, so it's important that you declare what you are using this word as in your context. Next, trusts. There are living trusts, which properties are transferred into during one's lifetime, and testamentary trusts, which properties are transferred into by provisions in a will. A testamentary trust is the kind that will be in your will, and you need to appoint a trustee to manage your will, as mentioned earlier. Trusts are completely optional. It's important to consult with an attorney or a lawyer to determine if they're necessary in your situation. It's also important to consult with an attorney or a lawyer about designating a trustee. Finally, I encourage you to work with a legal professional because it's never a bad idea to have help. Search for lawyers or attorneys in your area who specialize in end-of-life planning and have them assist you in planning for the end of your life in order to save your families from uncertainty during a time of grieving. Thank you so much for listening to my presentation, and I hope this helps clarify certain parts of drafting a will.